the SHM. Then on this ground alone, it is case that the respondents were liable to be disqualified for non-attendance of the meeting dated 21st June 2022 is liable to be rejected. In this conclusion that may be reached about which fact was the real political party, respondents could not be held to be disqualified on the ground that they deliberately remained absent in the SSLP meeting held on 21st June 2022. This is because of the following reasons. Petitioner relied upon the attendance sheet of the 21st of June 2022 to claim that all those MLAs who were signed the said attendance sheet were present in the meeting, while those who did not sign were not present. Based on this document, the UBD faction claimed that respondents remained deliberately absent. A comparison of the original attendance sheet produced along with the affidavit in lieu of chief examination of the petitioner Shri Sunil Prabhu, PW1, with the copy of the attendance sheet produced and verified as a true copy along with the petition, reveals that the two do not match. There are glaring discrepancies. The copy claimed to be the original of the said attendance sheet has a handwritten date of 21st June 2022, whereas the copy verified as a true copy of the original produced along with the petition does not have it. Further, Shri Sunil Prabhu stated in his cross-examination that the documents relied as the attendance sheet was in fact a register of MLAs to whom the whip of 21st June 2022 was served and received. So, facts show, one, there are many discrepancies in the said attendance sheet. Two, the statements of Shri Sunil Prabhu shows the document relied upon as attendance sheet of MLA present on 21st June 2022 is in fact a register of service and receipt of the whip dated 21st June 2022 of the MLA. Thus, the said document is unreliable and cannot be taken as proof of non-attendance of respondents in the meeting held on 21st June 2022. Hence, on this count as well, petitioner's case that the respondents are liable to be disqualified for non-attendance of the meeting dated 21st June 2022 has to be rejected. Further, all the respondents have denied the receipt of any whip for attending the meeting on 21st June 2022. Countering this, petitioner Shri Sunil Prabhu, in his affidavit in lieu of examination in chief, stated that the whip for 21st June 2022 meeting was sent via WhatsApp by Shri Manoj Anishchandra Chowkle to Shri Prabhakar Kare, PA of Shri Eknath Shinde. In the cross-examination of Shri Sunil Prabhu stated that the whip was sent via WhatsApp to all the respondents, who according to him were not traceable. However, petitioner has not offered any statement or any material to even suggest that such WhatsApp messages were sent to other respondents. Thus, the petitioner has failed to establish that whip/notice was served upon the respondents in petition number 2-15, directing them to attend the meeting on 21st June 2022. As to the service of whip on Shri Eknath Shinde, the only material produced by the petitioner is an alleged screenshot of the WhatsApp message sent by one Shri Manoj Anishchandra Chowkle to one Shri Prabhakar Kare. This does not constitute proof of any notice whip was served upon Shri Eknath Shinde, directing him to attend the meeting on 21st June 2022. Further, a perusal of the aforementioned WhatsApp message allegedly sent to the PA of Shri Eknath Shinde shows that the said message was sent at 12:31 p.m. on 21st June 2022 for a meeting which was allegedly scheduled for 12:13 p.m. Thus, it is abundantly clear that none of the respondents were ever served any notice with for the alleged meeting dated 21st June 2022. Hence, on this ground alone, also, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 21st June 2022 must be rejected. The third ground on which the disqualification of respondent is sought is that the respondent deliberately remained absent in the SSLP meeting held on 22nd June 2022. Petitioner relied on the attendance sheet registered of the meeting dated 22nd June 2022. After having considered the rival submissions, I hold that respondents cannot be held to be disqualified on this ground in view of my conclusion that 1. The Shinde faction was the real political party when rival factions emerged. 2. Shri Sunil Prabhu ceased to reflect the will of the political party from the moment rival factions emerged. Thus, it would not be correct to say that Shri Sunil Prabhu had any authority to call any meeting of the SSLP. Hence, on this ground alone, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 22nd June 2022 must be rejected. Again, even if I was to take different view about which faction was the real political party, still the respondents could not have been held disqualified on the ground that respondent deliberately remained absent in the SSLP meeting held on 22nd June 2022 for the following reasons. I am unable to accept the petitioner's submission that non-attendance of the SSLP meeting would make the respondents liable to be disqualified under paragraph 1A of the 10th schedule. I am of the view that non-attendance of party meetings, including legislature party meetings, would not attract disqualification under paragraph 2(1)(a) of the 10th schedule of the Constitution. Such an action cannot indicate that the members have voluntarily given up his membership of the political party. Not attending party meeting and voicing a difference of opinion outside the house are matters between the members and his party and have nothing to do with clause 2(1)(a) of the 10th schedule. Non-attendance of the meeting can at the most be termed as an act of dissent within the party. If viewed as a form of expression, it would be protected by freedom of speech and expression, which includes dissent and is not only an integral part of fundamental rights under Article 14, 19 and 21 of the Constitution, but is an aspect of the basic structure of the Constitution also. Therefore, even if the alleged non-attendance is seen as an expression of dissatisfaction, it cannot be treated as conduct attracting disqualification within the purview of paragraph 2(1)(a) of the 10th schedule. Further, I find the petitioner's reliance on Sriman Bahasaheb Patil versus Karnataka Legislative Assembly 2020 2 SCC 595 is misplaced. As in that matter, the disqualification was not only on the grounds of non-attendance of a party meeting, but was found to attract disqualification when considered with the surrounding circumstances, such as non-attendance of the assembly session along with non-attendance of meetings. Petitioner relied upon the attendance sheet of the 22nd June 2022 to claim that all those MLAs who had signed the said attendance sheet were present in the meeting, while those who did not sign were not present. Based on this document, UBD faction claimed that respondents remained deliberately absent. A comparison of the original attendance sheet produced along with the affidavit in lieu of chief examination of the petitioner Shri Sunil Prabhu PW1 with the copy of the attendance sheet produced and verified as a true copy along with the petition reveals that the two do not match. There are glaring discrepancies. The copy claimed to be the original of the said attendance sheet has a handwritten portion on top in which it is not which is not present in the copy annexed to the petition, verified as the true copy of the original. The original of the said attendance sheet has 17 signatures and in the copy annexed in the petition, verified as true copy of the original, has only 15 signatures. Thus, glaring discrepancies in the said attendance sheet makes the said document unreliable and hence cannot be taken as proof of deliberate non-attendance of respondents in the meeting held on 22nd June 2022. Hence, on this count as well, petitioner's case that the respondents are liable to be disqualified for non-attendance of the meeting dated 22nd June 2022 is liable to be rejected. With, in view of my conclusions reached above and the findings that the Shinde faction was the real political party when rival factions emerged, it would not be correct to say that respondents have incurred disqualification under paragraph 21A and the 10th schedule by passing the resolution dated 21st June 2022. Hence, on this ground alone, petitioner's case that the respondents are liable to be disqualified for passing the resolution dated 21st June 2022 must be rejected. The next ground on which disqualification of respondents is sought is that the respondents acted in concert with BJP. This ground is a mere allegation, and apart from the mere statement that the respondents have acted in concert with the BJP, the petitioner has not provided any material to substantiate the same. Thus, a bold, unsustained statement that the legislators have acted in concert with the BJP cannot be a ground to attract disqualification under paragraph 21A of the 10th schedule. The next ground on which the petitioner seeks the respondent's disqualification is that they made anti-party, anti-coalition statements. Again, this ground is a mere allegation, and apart from a mere statement that the respondents have made anti-party, anti-coalition statements, the petitioner has not provided any material to substantiate the same. Newspapers from media reports relied on the petitioner cannot be taken as conclusive evidence of anti-party activities. It can at most be only considered hearsay. Thus, a mere unsubstantiated statement cannot be ground to attract disqualification under paragraph 21A of the 10th schedule. In conclusion, I would like to make some observations about dissent, indiscipline, and what acts as indiscipline would attract disqualification under the 10th schedule. If some member or members in a given case go overboard and make some statements or do some acts which may be considered indiscipline, it would be for political party to deal with them appropriately. Looking at the degree and gravity of the indiscipline, the concerned member may be censored, admonished, or reprimanded, or given a mere extreme punishment such as suspension or expulsion from the party as may be warranted by party rules. The 10th schedule is not intended as a device to be used for imposing intra-party discipline, much less for administering the party. No party leadership can use the provisions of the 10th schedule as a deterrent to stifle the collective dissent of large number of members by threatening them with disqualification under the 10th schedule. In a given case, when a tussle for leadership arises between leaders in a political party, the elected members, as indeed the common party workers, usually cannot remain mute onlookers. They are compelled to choose sides. Whatever else may be the consequences of this action or inaction, the parties cannot expect that the high office of the speaker can be used to eradicate opposition or quell dissent in party ranks by employing the mechanism of the 10th schedule. In any case, the speaker has no role to play in this game of political tussle between warring party leaders. The speaker merely goes to the letter of the law and the spirit behind introduction of penal consequences in the 10th schedule, which in my considered view is to preserve the democratic foundations of the legislature or the parliament. I must keep in mind this object underlying the 10th schedule and ensure that the dispute falls within the provisions of paragraph 21A and B, and that his powers are not sought to be invoked with ulterior motives for party gain. In view of my conclusions and findings recorded herein above, petition number 1 to 16 of 2022 are hereby dismissed. Group 3 deals with petition number 18, which is also under paragraph 21A. So I am only reading the operative part because the preliminary issues, the ruling will be the same on that. So I'll go to the operative part of it. You can deal with the judgment order with regards to the other aspects. Yeah. In view of my conclusion and findings recorded herein above, petition number 18 of 2022 is hereby dismissed. The Group 4, petition number 19, which is filed by legislator belonging to the UBT faction under 21B.